Hey everyone, it's Laura from TheRealLauraB. Welcome to my channel here on YouTube, and I've been posting on Twitter. We did get the information, and I want to make sure that it's very clear this is not the appeal briefs that have been filed. As I had reported on Twitter before, on October 11th, both sides had filed their designations. That was updated. Vanity Fair apparently got the article, and we contacted the courts. Andrea got her email before I did. Kudos to Andrea Burkhart, but I also got my email, and I'm going to present to you right now what their points of designation are, their assignments of error by the judge, or how you want to say that. And yeah, let's get started on this.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Okay, here we go. Now, Johnny's lawyer has been caught, outside contracts and stuff, and they've been asking her chances on appeal. And she's basically said, hey, there's not a lot of law out there for us. So this is what they've gone, what they have. Oh, I may have to switch my connection, guys. If I do that, I may have to start over. We'll see. Somehow I got bumped out to Wi-Fi. So let's see what we've got here. And this is Johnny's first that I'm bringing to you, and I'll keep an eye on my Wi-Fi. Okay, the appellate John C. Depp, this is versus Amber Heard. This is his appeal designations. Appellant John C. Depp, plaintiff by and through his undersigned counsel, hereby submits the following assignments of error. 1, the trial court erred by denying Mr. Depp's motion for summary judgment as to the appellee Amber Laura Heard's counterclaim, and Mr. Depp's motion to strike the evidence as to Ms. Heard's counterclaim. Mr. Waldman is an independent contractor, not an employee agent, and Mr. Depp is not liable for Mr. Waldman's allegedly torturous conduct as a matter of law. The counterclaim statements by non-party Adam Waldman, Mr. Waldman, that are subject to Ms. Heard's counterclaim are not actionable statements sufficient to support a claim for defamation. Ms. Heard failed to present any clear and convincing evidence that Mr. Waldman made the counterclaim statements with actual malice. So this is what they want to make sure the judge sees, that the preserved plaintiff's memoranda to sustain demur, plea, and bar to all counterclaims. And this is the designation of the court documents they filed, which motion the parties argued before the court trial on October 16, 2020. And the trial court denied on January 4th, 2021, with respect to the 3 statements that ultimately formed the basis of the counterclaim. So this would be his demurrer that he filed. With respect to the 3 statements that ultimately formed the basis for the counterclaim at trial, plaintiff's memorandum in support of motion for summary judgment regarding counterclaim, which motion the parties argued and tried at the trial court, denied on March 24, 2022, right before the trial started, as further reflected in the trial's court order. Plaintiff's memorandum in support of motion to strike, which motion the trial court denied after argument on May 24th. And May 26th. So this was during the trial. Remember, during the break, they came up and said, hey, we want to strike her claim, and he was denied. The trial court erred in refusing Mr. Depp's proposed jury instruction number 22, 23, and 24 as to whether Mr. Waldman was acting as an independent contractor when he made the counterclaim statements. So that would have been, the court denied May 20th. The trial court erred in excluding from evidence the full unredacted versions of Mr. Depp's exhibits numbers 881, ABC, which are copies of the news articles in which the counterclaim statements appeared, instead admitting only redacted versions that showed the counterclaim statements out of context. That would have been on the jury forums. Copies of which Ms. Heard attached to her counterclaim, there you go, as exhibits F, G, and H, which plaintiff argued should be admitted in their entirety. This was signed October 11th. So let's see what we've got very quickly, because I know everybody's dying to know what's going on here. So first we have the plaintiff's memorandum dated October 16, 2020. So watch your eyes, guys. I'm so sorry, but that's what we got to do. God, a whole nother year. Watch your eyes. I'm not there yet. October. Still going. Wow. So this would be, what is there a date specifically? The 16th. Defendant's memorandum of support and motion to compel. Defendant's motion to compel. I don't think. Well, that's defendant. Sorry, guys. Plaintiff's reply for the demurrer and support of demurrer. This is it, October 5th. So I guess the precipice came in later. So this was his, he wanted to have that demurrer, to have the whole thing kicked of her counterclaim, and that was denied. So that's where that document comes from. Argued before the trial on October 16th, so that's the hearing, and the trial court denied on January 4th with respect to the 3 statements. So now we go to January 4th, 2021, and that would be the ruling. I'm sorry, guys, but this is what happens when it's last minute. Order dated, which date? 4th. Order dated on the 4th. That's the dedesignating. So it must be it must have, here it is, the opinion letter. Yeah, this is the opinion letter. This matter became for the court for John C. Depp's demurrer and plea and bar to all counterclaims. The conclusion of the hearing, the court took it under advisement to consider the following issues. Again, this is whether the court should exercise jurisdiction over defendant's counterclaim, whether plaintiff's statements are actionable. And again, that would have been Adam's statements. So a lot of these were time barred, if you remember, and we're going to go down to the final. Yeah, the defamation per se is overruled. It did require the requisite sting to hurt her career, although all these statements were time barred. And remember, only F, G, and H came in. And these were through Amber Heard and her friends in the media, the fake sexual violence. All of this came through Adam Waldman. Those 3 statements were the only things that survived. And as a result, they did let this go through. So that's just a recap and reminder of what happened back then. Let me get over here. I've got lots of comments. So that's that. All right. So we've got that one. And then he mentions the summary judgment we know came in March 24th. And they said, look, there's Adams. He had no malice when he did this, right? That was one of their big things, March 24th. Watch your eyes, guys, because I'm going to go way forward. Oh, it's going to be one of these. Motion's denied. So let's see. Plaintiff's motion for sanctions. Plaintiff's list of best and plaintiff motion for summary judgment. So this is what you're appealing, the judge's decision in this. So this was the summary decision to the defendant's anti-SLAPP immunity. So I think that never came into play. So was there another one he filed? Here's another one. And this is the motion for the summary judgment regarding the counterclaim. She has no evidence of direct liability. She cannot prove actual malice by Mr. Waldman, and the contract and the counterclaim statements are protected opinion. You remember Adam took a whole report to the LAPD and said, hey, she's lied here. She's perjured herself. Here's everything I have. Here's all these witness statements. Here's all these interviews I've done. And so they're claiming he did not act with actual malice. So what else did they claim? And I'll put all these links in the bottom for you guys to refer to, but I didn't want to just sit here and read these things at you. The jury instructions, 22, 23, and 24. So we don't know what he proposed. We're going to find that out. We know what was given, but we don't know what he proposed. The trial court erred in excluding evidence from full unredacted versions, which are copies of the news articles in which the counterclaims appeared. The statements are out of context. Ms. Heard attached to her counterclaim. All right, so we have to go find the counterclaim, guys. Hold on to your eyeballs, because that would have been August after the trial, right? Hold on to your eyeballs. That's where she finally, here's her counterclaim here. All right, this is 99 pages, guys. Hold your eyes, because what we're looking for is the attachments that she made. So let's see if they're in the bottom here. So she's complaining about his articles. So she is, in her counterclaim, here's the 911 calls. So this is Adam's statements. So it looks like they're all here. The trial court erred in excluding from evidence the full unredacted versions of Mr. Depp's exhibit, which are copies of the news articles in which the counterclaim statements appeared. Instead, admitting only redacted versions that showed the counterclaim statements out of context, copies of which Ms. Heard attached to her counterclaim as exhibits F, G, and H. F. Well, in the trial, this was all redacted, if you remember right. The only thing they showed was the one sentences. Everything else was redacted that was shown to the... So I think that's what they're complaining about, is if they'd shown them the whole article, they would have seen that Amber Heard's lawyers also commented. They would have seen the context of how he made these statements. So yeah, the entire article that was shown when I was sitting there was completely redacted. So I think that's what Johnny's saying, is that the entire document should have been showed, not just the redacted versions, because those are the exhibits that she provided. So that's very simply Johnny's. Now, we knew this was coming, right? Because he has it here. He had other issues. He has the all reasons stated in oral written arguments in Mr. Depp's demurrers, pleas, and bars motion. So he's cited that. The jury instructions, all reasons stated in oral and written arguments in Mr. Depp's motions, jury instructions. So they're including that. The court's legal finding that Ms. Heard could prove actual malice by relying on the mens rea of either Mr. Depp or Mr. Waldman. So that's a big part of it. They're including that. I don't see the hearsay statements. The court's refusal to sustain Mr. Depp's objection to improper argument made by Ms. Heard's counsel during closed argument. That was not mentioned. But this is the jury's finding of defamation by Mr. Depp as to the statement made by Adam Waldman that quite simply this was an ambush, a hoax, they said, etc. So Amber Heard, etc. As contrary to the law and unsupported by the facts. So he's citing that specific one. The jury awarded $2 million in favor of Ms. Heard against Mr. Depp in connection with the jury's finding of defamation was excessive and not supported by the facts. Yeah. I mean, Warner Brothers came on and said that they hired and kept working where there was no proof that showed she lost the $2 million. And so other ones. So that's what we've got. That's Johnny's, very clear and simple, but Camille said it's going to be tough. There's not a lot of case law for them. So that is Johnny's in a nutshell. So we good with that one? Hot talks for any post the documents. Post the documents as you usually do. Really appreciate that you do this with my bad eyes. What do you mean by post the documents? I'll put the link in the description. Is that what you mean? Because yes, I will put the links in there. Yeah, I downloaded them, so I'm going to have to put, they're not on a website. I'm going to have to upload them to DocDroid or something so I can share them. So yes, I will be sharing everything. Is there any other questions on Johnny's? Yeah, we're going to do Amber's next. Did I get any other questions? I don't see any questions here on Johnny's. Okay, so going on to Amber's. Amber Heard against John C. Depp. This is 4 pages, and these are her points of error. Let's see if there's anything new that she didn't already file. Comes now, appellant Amber Heard Laura Heard by counsel and designates the following as her assignment of error. The trial court erred in declining to dismiss the action on the ground of forum non-convenience. That was the very first one that her first attorney, Eric George, brought that said, hey, it shouldn't even be here in Virginia. So right off the bat, it sounds to me like they are going to pick every possible thing and throw everything at the wall and see what hits. So this is the first one saying, hey, it shouldn't be here in Virginia in the first place, dismiss it or move it to California. So that's what she's arguing this. The trial court erred in denying the supplemental plea in bar and ruling that November 2nd, 2020 judgment of the UK High Court should come in. Now that was an extremely detailed and reasoned ruling by Judge Ascarade saying, no, it's not going to happen. Amber Heard came back and said, we want an interlocutory appeal, which means we want to interrupt this court and appeal this right now. Judge asked, so we can save ourselves time and go to the Supreme Court. And Judge Ascarade said, no, I'm sticking to it. So we're not surprised that this did not come back in as an appeal. Guys, I have to ask, is my connection okay? Because it's looking low for me. Y'all can see everything good? The trial court erred in denying the demurrer and plea in bar and in ruling as a matter of law that the 3 allegedly defamatory statements in the challenged op-ed are actionable as statements of fact rather than non-actionable expressions of opinion and actionable as defamation by implication. So they should not have been actionable. The trial court erred in denying the demurrer and plea in bar and in the ruling as a matter of law that the 3 allegedly defamatory statements in the alleged op-ed are actionable as statements of fact rather than non-actionable expressions of opinion and actionable as defamation by implication. So they're saying that, and this is what they filed later on, that Johnny as a public person should not be allowed to claim defamation by implication. And they are opinion about what happened to her after the issue. So they are appealing everything. The trial court erred in excluding from evidence at trial the November 2nd judgment. Remember that went back and forth. They were not allowed to talk about that. The trial court erred in excluding from evidence at trial medical records, including Ms. Heard's contemporaneous communications with medical providers, such as Dr. Laura Anderson, Dr. David Kipper, Debbie Lloyd, Aaron Falatib, which we know is Aaron Borum, Dr. David Kipper, Nurse Debbie Lloyd. Sorry, I think I jumped a line there. Dr. Amy Banks, Dr. Connell Cowan, and Dr. Bonnie Jacobs, and Ms. Heard's communications with several third parties, including Mr. Depp's employees and Ms. Heard's employees, friends, family, about interactions with Mr. Depp, including reports of drug abuse, aggressive and abusive conduct, physical abuse, and her fear for her safety. They all took the stand as far as the doctors, the medical people, so I'm not sure what they were prevented from asking. A lot of that was decided if there were recorded depositions at the Friday hearings that they had about what was admissible and what wasn't, was considered hearsay, what might have been a prior bad act, etc. As far as discussion with several third parties, again, that's hearsay unless Stephen were to take the stand, and I'm sure that's what she's trying to bring in, that she had other witnesses that they did not call on either side. But I'm sure that has a lot to do with Stephen's text. The First Amendment, Stephen thinks the First Amendment argument will be thrown out. The argument that Virginia is the wrong jurisdictions is the strangest thing she has to appeal. That's why as soon as I read it, I'm like, they're throwing everything at the wall. The trial court erred in admitting evidence at trial relating to Ms. Heard's pledge to donate money to charity and evidence related to Ms. Heard's alleged abuse of third parties. So she wasn't allowed to talk about hurting her sister. I don't think that came up. Yes, maybe it did. Raquel answered the question that she had been hit. And of course, they were able to finally bring in her arrest because she's the one who said, I know you're not supposed to hit a woman, a man, or any person. She brought it out. As far as her donating money, even California, let me tell you, before this was done in Virginia, this was dragged through the California courts with LA Children's Hospital. And the judge there said, no, you put it out there in the public. It goes to your character. It goes to whether you're willing to lie to the public about things. And California said 100% it's in. They took the ACLU to New York and argued with that. And ACLU said, yep, New York judge said, yep, I can completely see how this can go toward her using the public media to support her lies. So several courts weighed in on this donation thing before the Fairfax did. So that'll be interesting. The trial court erred in excluding evidence at trial of Mr. Depp's reputation as it existed prior to publication of the challenged op-ed and after the op-ed was published. Well, I remember Ben Rottenborg reading off all those titles, so I'm not sure what more they were going to bring in, unless it's something to do with using Tracy Jacobs' prior testimony and depositions, but they had time to answer the questions. Thank you so much, Jazith. I appreciate it. Yeah, these I so appreciate it. I really do. And I was able to get these through the courts, open order. Okay. The trial court erred in sustaining an objection during the cross-examination of Mr. Depp to a question about the truth of one of the allegedly defamatory statements on the ground that it called for a legal conclusion. Interesting. These kind of things, a lot of the lawyers have covered. When the appeals court looks at the rulings, they're going to put a lot of weight on the rulings that were reasoned and drawn out and researched, and they're going to look at all the cases that were used and things like that. Rulings that are made from the bench on the fly in the mid-trial, the jury's going to, the appeal group is going to look at those differently. They're going to get less weight because it's like calling out the umpire at the baseball game. You know? Thank you, McSquirrel. I'm just so glad you're here to help moderate because I wasn't able to set any standards. And yeah, I really appreciate you. And you don't ever have to donate. I'll always try and find you. So that's interesting. So the legal conclusion one, yeah, that would have been made on the fly. And the appeals court will consider everything that was going on in the court and that last minute decision she had to make, the knee jerk. The trial court erred in allowing Mr. Depp to argue or suggest at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the challenged op-ed. Now, my understanding is that they did limit that he could have no damages lost before that. So I'm interested to see what that might be, because sitting there, I remember there's in the motions for limine, they were arguing that no damages could be shown. Although he did show that his Q score was remaining pretty good up until, she claimed abuse in 2016. He came back up to it. He did better. And then she wrote her op-ed and it crashed again. So anyway, the trial court erred in allowing Mr. Depp to argue or suggest at trial and the jury to consider whether the allegedly defamatory statements in the challenged op-ed were republications of statements misheard made in 2016 in connection with a domestic violence temporary restraining order she obtained against Mr. Depp. Well, that's what she put in the article. And she said 2 years ago. So they're trying to say 2 years ago should have been time barred, but the article was a reprint. She very much brought him up again. So that's going to be interesting legal opinion on that. The trial court, which rejected proposed jury instruction CC, improperly instructed the jury on actual malice. Interesting. She knowingly They said it. Did she knowingly, with disregard, reckless disregard, say it when she knew it was a lie? We'll see. The trial court erred in denying the motions to strike and to set aside the jury's verdict with regard to Mr. Depp's failure to prove publication by Ms. Heard of the statement, "I spoke up against sexual violence and faced our culture's wrath. That has to change." Ms. Heard insisted that she did not make that title, that the Washington Post chose that title. However, when she retweeted with comment, that title was in her tweet. She claimed she didn't read it. She claimed she couldn't see it. Well, she could. And we know that she posted a screenshot of it to her Instagram account. That would be new evidence that couldn't come in. But the jury believed. And she was the one who insisted on adding in the R testimony. She brought in the sexual violence. So that's what the jury went on. And she shocked them. And they shocked her back. But she insists that she did not create that title, but she retweeted it. And that's what they decided was a republication of it. So therefore, she acknowledged it. The trial court erred in denying the motion to set aside the jury's verdict with regard to Mr. Depp's failure to prove that the allegedly defamatory statements in the challenged op-ed each conveyed a defamatory meaning about him by implication, and that any such implication was both designed and intended by Ms. Heard. So we're supposed to believe none of that was about Johnny Depp. It was only about what happened to her, a person who claims TV, and not about what happened to her 2 years ago. And we should not have inferred it was about Johnny Depp. That's my reading. The trial court erred in denying the motion to set aside the jury's verdict and in ruling the jury's verdicts in favor of Mr. Depp on his claims against Ms. Heard and in favor of Ms. Heard and on her claims against Ms. Heard were not inherently and irreconcilably inconsistent. Okay, so what they're saying is, if you remember, they filed motions afterwards. How could the jury say, we find for Mr. Depp for all three statements, we find for Mr. Depp on her two statements, but we find for her on one statement? How can that be inconsistent? That if they find for Amber Heard on one statement, it should cancel everything out. And the judge gave a very recent statement saying, no, it's different context. They all still believed it was a hoax, but they may not believe that the lawyer told them to set the stage, that the lawyer told them to get their story straight, that they messed up the place before the cops came, or they called the cops twice. I think that was what was in the statement, which was information that Adam had at the time. So I think that's what they're saying here is, how can you have somebody find in favor of both people? It cancels each other out. And the judge, Ascarati, said, no, she didn't agree with that. The trial court erred in denying the motion to set aside the jury's verdict and upholding the amount of jury's damages awarded in light of A, Mr. Depp's failure to prove pecuniary damages, and B, the excessiveness of the compensatory and punitive damage awards. And they tried this with Judge Ascarati, and she said, no, I completely feel that the jury got this right, or got it right in their understanding, and that's what their role was. So this is interesting, Steve. When I heard on a video from a criminal attorney who worked in the Virginia appeals court as a clerk, he stated if more than 5 errors are presented, the judges will deny the appeal. Interesting. I think they only allow so many pages for their brief, so I'm not sure how she's going to cover all of this in her brief. So that means they're going to be pretty limited on what they're describing. Yeah, it was quick. It was a quick stream. So let's look at... This is what Amber Heard filed right after the motion. The damages of the jury were unsupported by the evidence. Basically, that's what she's appealing. The verdicts on the complaint and counterclaim are inconsistent. That's what she's appealing. The First Amendment does not bar recovery for defamation by implication, even when the statements at issue involve public figures or matters of public concern. She is saying that they should not have found Johnny was implicated. It would be up to her what her intention was of the article. The jury finding defamation regarding the op-ed headline was consistent with supported by law and facts. Is this Johnny's? Am I reading these backwards? Yeah. So that's Johnny opposing it, but it's the same thing. So I can still read them the same way. So this is Johnny opposing what her claims are that are now going to the appeal. The jury finding of actual malice is well supported in the record. She's saying it wasn't. Mr. Depp presented sufficient evidence to support a finding of defamation by innuendo. That's what she's appealing. Remember, she filed this. Depp opposed it. The court should not conduct an investigation of Juror 15. That's not even being brought up. I think they realized what a fool they made of themselves on that one. Mr. Depp presented sufficient evidence to support a finding of defamation from innuendo. Okay, so let's go back here and see if we can find the order. Sorry, guys. Watch your eyes. I got all the way back to the top. I got 2 years to go here. Okay. Let's see. One of these is the judge. All right. The protective order in the matter was put in place. All right. So this is to release documents. Post-trial motions 1 through 6 are denied for reasons stated on the record. And then, of course, the trial, what we already know about the jury was denied. So that's pretty much what she covered in writing, was only about the juror. Everything else was denied based on what the record says. So that's that. I think I covered everything else. All right, so she did file some stuff in the unsealed documents, and these were filed late. So this is filed on July 7th. Bench memorandum is a part of omission of statements for purposes of medical treatment. Ms. Heard's statements to treating psychologists, psychiatrists, and other care providers regarding abuse endured by Mr. Depp are reliable because they occurred in the context of receiving treatment. Let me blow this up for you so you can see it. So she filed this July 7th, which is what she's put into her memorandum, that more medical stuff should have come in, even though they said pretty much this was hearsay. Statements for purposes of medical treatment provides an applicable hearsay exception. It permits admission of the following hearsay statements. Remember now, her medical part that she's talking about here are be for therapists. They're not from the medical doctors, although she's saying some stuff was apparently kept out of the court. I'm just double checking questions because I don't want to go too deep and not. Yeah, who's still paying for it? As far as we know, Deadline reported that Travelers is still paying for this, which is why she's trying to get the malice overturned for sure. That's the most important thing. Her personally has to get overturned first and foremost so that her bills are paid for. And then, of course, she wants the whole thing overturned. Now, as far as we know, Deadline reported that Travelers is paying for it. I wonder if Johnny's attorney can point to the fact Amber admitted the editorial was about Johnny. It would be in the court documents. Now, again, he's going to rebut. They're going to rebut each other's points. So here's what she filed, that Ms. Heard went to several psychiatrists and psychologists for the purpose of getting treatment for her volatile and violent relationship with Mr. Depp, including occasionally attending in joint sessions with Mr. Depp. As part of the treatment, Ms. Heard revealed his violence and abuse toward her. For example, December 17, 2015, long before Mr. Depp and Ms. Heard's relationship ended and long before there was any public allegations, Ms. Heard informed her psychiatrist, Connell Cowan, who provided a psychotherapy for Ms. Heard and Mr. Depp, was physical. Mr. Cowan's contemporaries notes state Amber related that he started the physicality, pushed her down. This statement falls squarely within the medical treatment hearsay exception. So now we have a pinpoint of what she wanted from Connell Cowan. So that's, I'm just rushing through this, guys, because I don't want to sit here and read at you all day long. How can the claim of Depp's loss of earnings did not meet pecuniary validity when she was countersuing for a fantastic, $100 million? Because he got her the role. Again, that's what they're going to appeal. They're going to say that he hurt his reputation enough beforehand that he didn't get Pirates back. So that's pretty much what she filed on that. And the other thing she filed, let's see what this one is. Filed April 1st. She wanted a reconsideration. She filed for one of the limines. And this was about the Australian dogs, that she wasn't going to use it. But I guess Ms. Heard was not convicted of a crime. Likewise, allegations that she lied to immigration. Ms. Heard's motion on March 3rd, court ruled something. This rule did not apply to the letter for counsel from Warner Brothers, stating that they would be willing to provide a declaration as opposed to being deposed. Subsequent proposed stipulation from Ms. Heard to resolve the discovery dispute. The evidence falls squarely within rule. I don't remember any of these letters coming up. I just remember their deposition testimony. So I don't see that coming in with her appeals right now. So we have just a few points from Johnny. We have what he had already filed. We have her 16 points. And again, these are her designations that I think the court made an error here. And she looks like she's going from day one. She's throwing everything at the wall to see what sticks. Did I cover everything I wanted to cover? We got the order. Which one was this? We saw that. This is his summary judgment. We looked at that again, and I'll put all these in the bottom so you can read through them again. Motion for, this is the anti-slap. That never came in, so that's not what they're, and then of course, using the UK judgment. So yeah, she's putting it all in there. Yeah. I hope the appeal bites her in their ass. This is a Hail Mary. She's got nothing else to do now. Andrea said she's done some great videos. I'm not saying she can't win on something. I'm not saying they might not want to take something to the Supreme Court, like the defamation by innuendo on a public figure. Who knows? But even if they find the judge made certain errors, then the appeal has to decide, were those errors strong enough to change the outcome? Is it worth throwing out this entire trial? Would that have made a difference? So that's something they have to consider. I don't see Eve Barlow. I have no idea what she's doing. I know she doesn't seem to be hanging out with Amber right now. Yeah. Do we want to look at that jury instruction real quick? On malice. Here's the jury instruction. They decided that they did not describe malice correctly, that she's appealing that. Guys, hold your eyes. And they're in no order, so I got to look for them. I think it's pretty far down, actually. Defamation by implication. She is appealing that. Let's take a look at that. A statement that is not directly defamatory may nonetheless suggest a defamatory meaning in an indirect way. This is by implication. In determining whether any of the statements have a defamatory implication, you must consider the op-ed, make that bigger, as a whole and the circumstances surrounding its publication. You should consider if the circumstances show that the words used are defamatory and relate to Mr. Depp. However, such circumstances cannot extend to the meaning of the words used in the op-ed beyond their ordinary and common meaning. The proposed implication must be reasonably drawn from the words actually used. The words were used 2 years ago. I would say that was pretty clear. Hey, thank you. You are awesome to keep up despite the crap you've dealt with. Never let the bullies win. Thank you so much. What did Ms. Heard? Oh, it's not moving up there. What did Ms. Heard go to the psychiatrist and a psychologist? Both by law would have to report the abuse if they believed her. That's an interesting point, Steve. That's come up several times, why nobody reported it if it was actually reported to them. So watch your eyes. I got to go down. Actual malice. Both parties have the burden of proving actual malice by clear and convincing evidence. To meet this burden, each party must prove by clear and convincing evidence that each statement was made or published with knowledge that the statement was false or so recklessly as to amount to willful disregard of the truth, that is, with a high degree of awareness that the statement was probably false. Actual malice is a subjective analysis that looks to the state of mind of the person who made the statement. If the person who made the statement believed it was substantially accurate at the time of its publication, then it does not give rise to liability for defamation. That's interesting. So we'll see, because one of the things she was arguing was, there was two things. She said, it's what happened to me after I made the claim. So that happened to me. So that's what she's saying. But she kept saying 2 years ago, she, referenced her claim, everything that came out, not just her filing for the TRO, but the fact that she sold the story to people. So it went beyond the court documents. So that's that issue. And then somebody was saying, well, if she really, I remember her stand saying, well, if she really believed she was verbally abused say? If she really believed she was abused, then she believed it was the truth. That's going to be interesting. So that's what I've got. We have of course, the article that came out on Tuesday. Amber Heard filed the appellate brief listing 16 grounds for appeal 4 months after the jury awarded her husband $10.3 million in damages. Is there anything in here that's new? Include everything from a lack of clear and convincing evidence for actual malice. So, some of the grounds we already knew about for post-trial interviews. The trial court erred on allowing Mr. Depp to argue or suggest a trial that the jury could award on the title. Yeah, I think we covered it all, guys. So any other questions here? Because I know it was fast and furious. I just needed to jump on. I am not doing a weekly roundup this week. I have a wedding on Friday, so I'll be doing family stuff tomorrow, Friday, Saturday, and Sunday. I have a video that just went out. I have to keep track. I don't even know what videos I had out. Hold on, guys. I've had so many. Let me give you a schedule of what's coming up. Yeah. So I've been putting together some pretrial stuff, unsealed stuff, new stuff. And the YouTube studios give me a hard time. I just recorded today Ari Jacobs versus Taylor Lorenz lawsuit. She just refiled. I think that's really important because of the way Tug was affected and Legal Bites. And she even interviewed Andy Stigner from Popcorn Planet. That doesn't want to come up. Let me see if I can get it. So I've got that done. I did part 1 of the Warner Brothers pre-trial Battlefield. Part 2 will be the motions in limine that were unsealed and getting that one. So that's another video that's coming up. Yeah, I think the malice part is what they're not going to be able to prove. I think that's where they're going to get it because he interviewed all these people. He had enough evidence to try and go to, sorry, I'm trying to get stuff up for you, to go to LAPD. So he certainly didn't act with malice on this. He acted with what he believed to be true. So as far as, I've got her arrest coming up and how that got into trial. So that's on the 17th. So Friday is the Warner Brothers Part 2. Monday will be Amber Heard's arrest. And I will be getting out Ari's lawsuit. And now this is live today. I had to get this one out. So this is my weekly roundup, if nothing else. Yeah, so I've got a few that I'm putting together. So I hope that's stuff that you're interested in. At the end of the day, she can never erase what we saw on the stand. That is so true. And I've said this before, appeal or no appeal. We cannot unhear, unsee with our eyes, unsee the testimony that was given, the audios, the videos. We can't unknow any of that. And there's no question whatever that the jury got it right. 7 people unanimously said she lied. Is something going on with Winona forever? For me or for her? Age took a poop on the streets of pants. It's BS. You can't follow that guy. He lies, people. He lies terribly. His videos are BS, and they just make us all look bad. Please. He has a right, and they didn't bring that up. But and actually, I thought Depp might bring it up, that they should not have been able to put him in a position to keep claiming lawyer confidentiality because that's a standard claim. But we'll see. We'll see on that. I didn't see it. I didn't see the First Amendment. Oh, we did a little bit. Wait a minute. Let's just not give up too quick on that one. Let's see where her claim is. The trial aired in the trial aired in denying demurrer and plea and bar in ruling as a matter of law that the 3 allegedly defamatory statements in the challenged op-ed are actionable as statements of fact rather than non-actionable expressions of opinion. That's her First Amendment right there. They should have ruled that these were non-actionable expressions of opinion. And they also erred in actionable as defamation by implication. So yeah, that's where her First Amendment's coming in. I'm jumping around trying to find someone. Yeah, she said it was about Johnny, but yeah, it's basically she's saying it's her opinion. Yeah, we can never unsee it, unhear it, unremember it. And it's on YouTube forever. Her arrest was brought in because of Kate Moss opened the door to previous partners. But she also said, I know it's not right to hit a woman, a man, or any person. And that's what partially brought it up. Because that motion was made later on in the trial. Hold on, I brought something else up here for you. Let's see. Unsealed documents. Let me screen share this again. Let's see if I can find it. Okay, so in these documents, down toward the bottom, it would have been plaintiff's objections. It was heard during the trial. So the trial was on. Here it is. John C. Depp in his memorandum. So the trial was on. This was filed May 16th. Mr. Depp should be permitted to engage in the following limited inquiry. Let me blow it up for you. As to Ms. Heard's prior acts of violence, including the assault battery of her ex-girlfriend, Tasya Van Ray, as Ms. Heard's related arrest. This is her testimony. Isn't it true, Ms. Heard, that you've been, this is what they want to ask. This is what they want to ask her. And this has been going back and forth, but this is, here it is. Third, Ms. Heard has opened the door with her own testimony saying, I know you don't come back from that. I mean, you can't hit a woman. You can't hit a man. You can't hit anyone. So that's where they're saying that she opened the door to this, to bring this in. The USA Today article had Amber Heard was arrested and charged. So they're using that as evidence and ordered that Mr. Depp's limiting 5 to exclude testimony regarding Mr. Depp's prior arrest and incidents of violence is granted as to liability issues and evidence and testimony regarding the request, but is denied as to reputation issues for damages. So they were allowed to bring it in for Johnny as far as damages. You know, if they thought his reputation caused him to lose money. What else questions do I have? I know the lawyers are going to be covering this really big and deep, but this gives you a chance to get the overall, and then you can see that. Virginia was the right place. Yeah, Virginia was the right place. That was Judge White's, and he was very adamant that that was the right place, Virginia, to do it. Eric George did not do a very good job on that. That's one of the few first transcripts of a hearing we got to. And she filed Eric right after that, is our understanding, our reasonable conclusion. She was arrested and spent the night in jail, and they couldn't even go into details. I'll tell you one detail I'm dying to know. Where was Tasya after she was arrested? Did she get on a plane and leave? Did she go to a hotel and wait for her to get out the next day? Because apparently she didn't go to court with her. I still find that interesting. If she wins jurisdiction, then it helps, as in California, defamation by implication is not allowed. Virginia is one of the few states that still allow it. And that may be the law that they want to challenge up on, that Andrew was referencing to. The other states don't have it for public people. So anything else, guys? I think I got it all. We've been on here for almost 50 minutes now. And I'm really thankful I got a chance to jump on and make some sense of this. I'm going to close it out. Again, I'll be posting Warner Brothers Part 2 on Monday. I want to get Aries Jacobs versus Lorenz Taylor versus New York Times out because I think it's so timely to what's happening with us. Do I think any of her? I don't think any of her points are strong. I think that's why they're bringing so very much. Even if they say the title, right? Let's say they say the title of the op-ed should not have been included. I don't think that'll throw the verdict out. I don't think that'll cause a new trial, but that's my non-legal personal opinion. I don't think it's, I think it's exactly what we expected. I think it's exactly what Judge Ascarati already ruled on. I think it's already what Johnny Depp's team opposed. You know, I was starting to go over that, and I'll put those links in the bottom. So these are very, I mean, the only knee-jerk one was that it was a legal conclusion, that they shouldn't have objected to that. I don't think there was any on-the-fly rulings that they brought in. But I'm going to go. I'm going to get those links down for you. It's 2:30 for me. I have not had breakfast or lunch, and I'm starting to get the shakes. So I'm going to go. Thanks, everybody. I so appreciate you popping in here. We had up to almost 1,000 people at one point. I was shocked. I mean, I was gobstopped. But anyway, here we go. Let me get all these links up for you, and I will be back soon. Thanks. Bye-bye, guys.